well as the YouTube, which caused a bit of clash on the technical side, and that's why we couldn't time. And I do apologize to everyone on the platform as well as the honorable members. Unfortunately, technology can help you in many ways, but when it doesn't work, it also causes a lot of problems. Then I would just like to welcome the following people. The Honourable De Huys, who will be co-chairing with me today, as well as all the other honourable members on the platform. Then the listeners from the 8 community radio stations, as well as the other platforms that we are still on. I'd also like to welcome Mr. Rudy Louw from Namakwa region, as well as Mr. Zweni from ZFM and Mr. Maneni from Pixley Kaseme. We are dealing with 3 bills. The one is the Independent Demarcation Authority Bill. Then there are the Public Service Amendment Bill, and we are also going to deal with the Public Service Management Bill. Now the first one, the Municipal Demarcation Bill, will be presented by Mr. Ntlamulo Mati. The Public Service Amendment Bill, Mr. Jantjies, and yes. Okay, so I think we can then move over to the third point on the agenda, and that would be the presentations of the bill. The Independent Municipal Demarcation Bill will be presented by Mr. Marty. Mr. Marty, you are welcome to continue. I thank you. Yes, thank you. You are audible on our side.
been happening since the board has started delimitation rights and boundaries across the territory of the country. And these amendments were also informed by various inputs from various stakeholders, your SALGA, your IEC, members of the communities, your provincial departments, your national departments have also made inputs on the provisions that are contained in the bill. The development of the bill, Chair, started around 2017, where there was a stakeholder meeting seeking to identify clauses that can be improved. There was also a workshop in 2020, which happened after the ministers published the bill for comments. This workshop seeks to consider the various comments that were received. I can categorically say, Chair, we received more than 1,000 comments, which were considered by that workshop that was convened in December 2020. Chairperson, due to the number of proposals that are contained in the bill, it necessitated that it be repealed and be replaced by this act. The principal act will no longer be there once the President signs this act. And this is not the first time it's happening. Members will recall that it happened with the Human Rights Commission Act of 2013. So we believe these various comments that proposals that are contained in the bill necessitate that it be repealed and in its entirety and this new legislation take over the functions of the board. This slide, Chair, provides for the development and evolution of the bill, and it indicates that the bill has been approved for introduction into Parliament by Cabinet on the 23rd of March 2022. The bill followed all the relevant processes, including compliance with Rule 276 of the National Assembly, which deals with the introduction of the bill into Parliament. The bill was referred to the Portfolio Committee in the National Assembly, which held public hearings across the country during the month of July, August, and September in the year 2023. This resulted in the bill being referred to the National Council of Provinces, where the Select Committee was briefed in February last year. However, the bill could not proceed due to the limited timeframes that the National Council of Provinces and the Provincial Legislatures had to deal with the bill, and it resulted that in the bill lapsing. The bill has been revived now, hence we are at this stage where we are, Chair. This bill, Chair, has got 52 clauses, which spread in 5 chapters. The first chapter deals with the definition and purpose of the Act. The second chapter deals with the establishment of functions up to the finances of the authority. Chapter 3 deals with the gist of the demarcation processes, and it also introduces the new Demarcations Appeal Authority, which I will discuss a bit later in detail. Chapter 4 deals with the municipal capacity assessments, which I'll also deal with a bit later in section 47. And then chapter 5 deals with miscellaneous matters, which relates to transitional matters, regulation, and other matters similar to other pieces of legislation that are passed. Chair, as I indicated earlier, once the President assent to this bill, its name will change. We won't have the Municipal Demarcation Board Act now, but we'll have the Independent Municipal Demarcation Authority. This is aligned to the requirements of Section 155(2) of the Constitution, which requires that national legislation must establish a criteria and procedure for the determination of municipal boundaries by an independent authority. So basically, we are aligning with the requirements of the Constitution to say now that this is an independent municipal demarcation authority. The bill, Chair, provides for the establishment of the IMDA. It deals with the criteria for the determination of municipal boundaries. It deals with the delimitation of wards, capacity assessment, as well as the apex authority, as I've indicated earlier. So one of the bill defines the various terms that are contained in the bill to ensure that its interpretation is universal across all stakeholders and community members that will be using the bill. The various terms that are defined here include the appeals authority, the board, municipal capacity assessment, etc. Clause 2 deals with the purpose of the Act and indicates that the establishment of the IMDA and set criteria and procedures for the determination of municipal boundaries by this independent authority. Clause 3 deals with the establishment of the authority and it aims to differentiate between the board and the administration. You will recall currently, Chair, that there is no delineation between the board as appointed by the President as well as the administration that seeks to assist the board in conducting its function. So we're now saying that the authority will then refer to the board and the administration, and then administration will refer to the employees that are employed to assist the board in ensuring its functions. So this is trying to differentiate so as to ensure that the functions conferred to the board in the Act are clearly delineated as to where they, as to either they refer to the administration or to the board as appointed by the President. Clause 4 deals with the status of the authority and indicates that it is a constitutional institution which will be independent and impartial when performing all its functions in terms of this Act. And Clause 5 deals with the functions of the authority, and there are 4 major functions that are being conferred to the board by this piece of legislation. And most importantly is the one that relates to rendering advisory services in relation to the conducting of municipal capacity assessments. Clause 6 deals with the powers of the authority, and it indicates that there are various powers that are conferred to the authority to ensure that it is able to perform its function, and that it may be able to determine staff establishment as and when it's necessary to ensure that it is being assisted to perform its functions. Clause 7 deals with the removal of the requirement of regional diversity as it was provided in the present Act, and replacing it with broadly reflecting the composition of the South African society. You'll recall, Chair, that previously this was construed to mean that every province should be represented in the board, but that was not the intention of the Act. So now we're saying that the board should reflect the composition of South Africa. Additionally, Chair, this clause indicates that the members of the board will not be more than 10, and they should also not be less than 7, as determined by the President. Clause 8 deals with the responsibility of the board. And it indicates that the board is responsible for the corporate and governance of all the matters that the authority is required to perform in terms of this Act. And Clause 9 deals with the qualifications of board members. In addition to the qualifications, that is the requirements of knowledge in geography, requirements in planning, the requirements in economics. We're now adding a requirement to say that board members should have a knowledge of information technology for them to be able to conduct the functions of the board, given that the work of the board is generally technical. It uses ICT extensively. You will know that the board uses systems like GIS and other relevant planning systems in order to perform its functions. So we believe that adding the information technology will be a beneficiary to the board members. Clause 10 deals with the appointment of board members. We are indicating, Chair, here that the selection panel that will be interviewing board members should consist of the members of the portfolio committee. Should also comprise of the chairperson of the National House of Traditional Leaders. We are doing this since these are institutions that have got interest in the conducting of demarcation and municipal boundary across the country. And we're also requiring, Chair, in this clause to say that within 30 days of receiving a notification of a vacancy, the minister may now recommend a person from the list of people who went for an interview to replace a vacancy. This is aimed at ensuring that there's no delay in filling of vacancies in the board. Clause 11 deals with the term of resignation of resignation of board members, and it indicates that the term of office is 5 years, which should be calculated from the date of appointment. And we are requiring now that it should be aligned with the term of municipal government, This is aimed at ensuring that one board is responsible for determining municipal ward limitations across the country. Then we're also indicating in this clause, Chair, that a member of the board may not hold office for more than 2 consecutive terms. Clause 12, Chair, deals with the condition of appointment of board members, and the clause indicates that the conditions will be finalized by the Minister of Cooperative Governance, of course in concurrence with the Minister of Finance. And clause 13 deals with the chairperson and deputy chairperson of the board. This is just a practical matter to ensure that in an event where the chairperson is not available, the deputy chairperson fulfills the functions of the chairperson as conferred to by this Act. And clause 14 deals with meetings of the Act, and it indicates that the majority of board members in office constitute a forum. Therefore, a forum means all the majority of members that are there, as established by the President. And it also provides for the chairperson to have a casting vote in an event where there is a tie when votes are being made on any matter that the board is considering. Then the chairperson will now have an additional vote that's called a casting vote. Clause 15 deals with the rules of procedures, and it indicates that the board must determine its rules and procedures for conducting meetings. These include technical matters like how meeting minutes will be taken and recorded, as well as other matters that are administrative in nature. Clause 16 deals with committees, and it requires that the board may establish relevant committees to assist it in conducting its function. But then it requires that these committees, which are critical in nature, be established. This relates to Governance and Risk Committee, as well as the Remuneration and Performance Committee. The Portfolio Committee Chair was of the view that the names of members of the committees must be published in the website of the authority to ensure transparency. So now it is a requirement that not only the board members' names must be there in the website, but also the members that constitute the committees of the board, they should be published in the website of the authority. Clause 17 deals with delegations and instructions of the board, and it indicates that the board may delegate any of its powers and functions to any employee, but not the power to make the final decision. This is aimed at ensuring that the board is accountable for every municipal boundary and what limitation decision that they take. Clause 18 deals with the conduct of board members, and it requires that board members should perform the functions of the board in good faith, without favor or prejudice, and they must disclose all their interests. Clause 19 deals with the Chief Executive Officer. You will recall, Chair, that the Principal Act now that is currently in operation indicates that the head of administration is a manager. So to align with the requirements of other constitutional institutions, we are now saying the head of administration is the CEO and will be a CEO for a period not exceeding 5 years. Clause 20 deals with the condition of employment of employees, and it indicates that the board got a responsibility to determine the conditions of all their employees, but these conditions should comply with the principles of administration as contained in the Public Administration Act. And we're also indicating that the board may receive secondments of officials from other institutions to assist itself in performing any of its functions. Clause 21 deals with contracting of services, and it indicates that the board may contract an individual to assist itself. Whoever individual or institution is being contracted is entitled to reimbursement. Clause 22 deals with funding, and it indicates that the authority will only receive funding from Parliament through the National Revenue Act. This is to ensure that the board doesn't really receive funding from external sponsors and other institutions, so as to avoid so as to avoid any conflict of interest and it being influenced unduly so. So we're indicating that it will only receive funding from the National Revenue Fund. Clause 23 indicates that the authority must determine boundaries in accordance with the objects of local government as provided in section 52 of the Constitution, and this should also be aligned to the requirements of FLUMA. Clause 24 Chair, provides the various factors that the board should take into consideration when delimiting wards as well as municipal boundaries across the territory of the country. But importantly, Chair, this clause adds a new requirement or factor to say that the views of the people and the communities living in the area should be taken into consideration. We believe this clause will come in handy in ensuring that public participation and the views of people are considered. Clause 25 might raise the various functions of the board as they were contained in the Municipal Structures Act. This relates to the categorization of municipalities as provided in section 2 and 4 of the Structures Act. So we felt now that let's move all the functions of the board from the other pieces of legislation and let all the functions be contained in one piece of legislation. So these two functions will now be moved into this act from the Structures Act. Clause 26 deals with the initiation of determination of municipal boundaries. And we're saying that the board will undertake boundary changes that affect more than one ward. We're referring to major boundaries only every after 10 years. This is aimed at ensuring that there is stability, Share, and not every 5 years or every 2 years municipal boundaries are being changed as they affect municipal planning and other functions of the municipalities. We're also indicating that the board will not determine or redetermine municipal boundaries after the minister published the formula for a number of councillors. This is aimed at ensuring that the preparations for elections are not hindered by this process, since the board will be required to redo municipal ward delimitation, and that might affect and delay the processes for the preparation of municipal elections. Clause 27 deals with notification of intention, and it requires the authority to publish a notice in an area indicating its intention to determine municipal boundaries. And this clause also requires the board to invite written representation and views of the public within 30 days. And it also requires that specific institutions, they should be targeted for inputs. This includes your traditional and Christian leadership structures. Clause 28 deals with the conduction of investigation, and it requires the board to conduct a formal investigation when it's about to redetermine municipal boundaries. This investigation may be undertaken by the board itself or its committee or any other person on its behalf. After a formal investigation, a report must be submitted to the board for endorsement and for decision. Clause 29 deals with public consultation, and the idea, it requires that the authority should publish in a local newspaper informing stakeholders of a public meeting. The authority should communicate this means for public communications through your visual platforms and other applicable means. It can include your radios and all other means relevant to ensure that communities do attend these public hearings so that their views can be heard. Clause 30 deals with mechanisms, and it just confirms what I've just indicated, Chair, that the authority has got the powers to conduct public participation through other means, including your virtual platforms and other relevant means through your civil organizations that represent communities. Clause 31 deals with publication objection to redetermination of municipal boundaries, and it indicates that the authority is now obliged to publish its final determination in the provincial gazettes for comments, and after that it should object, vary or confirm that determination after considering the comments that they received. The board must also provide reasons for its decision, whether it agrees or not agrees, this decision can be provided to the members of community or whoever requested the board to determine municipal boundaries through other means. This can include publishing these reasons on their own website. Clause 32 deals with when a boundary determination takes place. And in this clause, Chair, we are indicating that after finalizing of a municipal boundary determination, the authority should inform the IEC and the MSC for local government in the respective provinces for their input and views. Clause 33 deals with the delimitation of municipal ward processes, and it indicates that the authority must publish a delimitation of wards timetable in the government gazette after the minister have published the formula for the number of councillors. This is to ensure that members of the public and stakeholders are aware as to when the municipal demarcation board will undertake ward delimitations across the country. This is to also ensure transparency in that process, Chair. Clause 34 deals with the number of wards, and it basically indicates that the number of wards should be equal to the number of ward councillors as determined by the MSCs in terms of Section 18 of the Structures Act. Clause 35 deals with the criteria for the delimitation of municipal boundary wards, and it indicates here now that the board has got the leeway to vary in the number of registered voters within a ward up to 30%. You'll recall, Chair, that currently the board has got a leeway of debating for the number of registered voters within a ward by 15%. So this does give the board a leeway to deviate up to 30%, so as to avoid your splitting of wards, your splitting of areas of traditional leadership. You'll recall that there will be an outcry in the country where you find that a settlement is split in the half. Maybe the living area is in another ward, the bedroom is in another ward. So by giving the board a leeway of 30% to deviate, it will mean that the board will be able to configure wards in a manner that doesn't split communities as well as areas of traditional leadership, as I've indicated. So we believe this word will come in handy in that regard. Clause 36 deals with public participation as it relates to the delimitation of wards. The process that I've indicated earlier in clause 22 also applies. Clause 37 deals with the publication and objections to the delimitation of wards. And similarly to the municipal demarcation process, we are indicating that the board should provide reasons to those who have submitted objections on the ward delimitation. They can do it specifically to those individuals, and they can also do it through their official website. And clause 38 to 46, Chair, deals with the demarcation appeals authority. This is a new structure that will be responsible for appeals and dispute resolution in the matters of municipal boundary redeterminations. You will know, Chair, that this process has been faced with a lot of violent protests, court actions. Sorry, where community members were not in favor of the decision that has been taken by the board. This has resulted to community members launching litigations in courts, and this is costly, and it costs community members. It also costs the board to defend such. So now we're saying this clause will establish a new institution which will be called the Demarcation Appeals Authority, which should be an appeal mechanism and provide dispute resolution mechanism in an event where communities and other relevant stakeholders are not certified by the decision of the board. This slide provides a summary of the process that I've indicated. Maybe in the sense of time, I'll just pass through it and jump straight to clause 47, which deals with the requirements for the board now to conduct municipal capacity assessment. This clause indicates that the board is required to conduct municipal capacity assessment before it makes a decision on the demarcation of municipal boundaries. It also requires that the board should also provide assistance and guidance to the minister and the NEC regarding the powers and functions of relevant municipalities to assist the NEC to know which municipality will be better suited to perform specific functions. This clause chair also indicates that the Municipal Demarcation Board will at least be required to conduct one capacity assessment within the term of 5 years, and that it may undertake a midterm assessment every after 24 months if it so needs. Clause 48 deals with the regulations and guidelines. It indicates that the minister can promulgate regulations and guidelines on any matter that is prescribed in this act. The minister should submit a draft regulations to Parliament for parliamentary scrutiny at least 30 days before their promulgation. This is an intervention that has been included by the Portfolio Committee in the National Assembly to say that it should have parliamentary oversight in this process, whereby the minister is required to promulgate regulation. So this is simply to ensure that there is oversight in that regard. Clause 49 deals with offences and penalties. Chair, the present legislation that is in operation doesn't provide the board with an option to sanction individuals to come to it to provide information as it may deem necessary to make a decision. So now this clause empower the board to summon an individual to provide information on any matter that will be necessary to enable it to make an informed decision. Clause 50 deals with amendments of laws, and it repeals the various provisions that are contained in the Structure Act, as I indicated earlier, as well as repealing the entire Act due to the many provisions that are contained here. Clause 51 deals with transitional arrangements, and then Clause 52, which is the last clause, deals with the technical matter of what the Act will record once it is assented by the President. This slide shall provide for the summary of the key features that I've indicated earlier. This relates to the naming of the bill to align with the provision of the Constitution, differentiating between the authority, between the board and the administration, the requirement to have majority determinations every after 10 years, the enforcement of public consultation, public participation in wide delegation processes, as well as the establishment of the Demarcations Appeals Authority, and lastly, the requirement for the board to conduct municipal capacity assessment. We do believe that this provision will come in handy in ensuring that service delivery is improved, particularly in the provision of the Big Four functions. This slide speaks to the various proposals that were made by the Portfolio Committee in the National Assembly. Majority of them I've went through. Maybe for the purpose of this session, I should just emphasize the proposal that was made to Clause 32, which requires that now at least within 9 months and not 6 months after a municipal boundary determination take place, the Minister of Finance and the Minister of Culture should be informed and let known of that determination. This is to ensure that transitional measures are in place before a municipal boundary determination take place. And as well as the one on Clause 48 have requested that Parliament was of the view that it needs to have an oversight on the regulations that the Minister promulgates in terms of this act. Honorable Chairperson and the member of the public, this marks the end of our presentation. Thank you very much.
Thank you, Mr. Kumalu, for a very good presentation, and I also want to extend my thanks to the team that compiled this. For all the stakeholders on the platform, there will now be 30 minutes time for stakeholder engagement, where questions of a clarifying nature, or, as well as inputs, can be made. I just want to request you to bear in mind that written submissions can also be made by the 2nd of May. So there will be an opportunity for all the stakeholders to also submit written submissions. So keep that in mind when engaging with the department on these issues. I thank you. I once again give over to the department for the engagement process. Thank you. Just a point of clarification. I think we will start then with the region where I am situated at the moment, the Francis Baard District Municipality, and then we can go to the Namakwa region, and then to the ZFM, and then to the Pixley Kasheme. And all of them afforded 30 minutes at a time. 5 for questions? No.
It will be 30 minutes for them, and then the responses will be 5 minutes.
5 minutes, yes, it's 30 minutes per region, and then after that there will be responses from the department, and the responses, please keep it to 5 minutes. I thank you. Okay, I will then open the floor for our region, for all the public currently in the House. If there's any clarifying questions, you may ask them, or else if you want to give any input, you are more than welcome to do that. Are there any questions from the members of the public in this venue? I don't see any hands at the moment. Are there any questions from the platform side? IT team, please just check on the platform whether there are any questions to the department. There's also no questions on the platform. I think then we can then proceed to the Namakwa region. Mr. Lowe, I hand over to you to request any inputs from the public in your venue, and then after that also request from the platform any questions or inputs. Thank you.
Is that I have to request the public to do written inputs, and that is exactly what they have indicated. They do not have questions at this stage, and they do not have any comments, but they will rather opt to submit the written inputs by the 2nd of May. Thank you.
Thank you. Thank you, Mr. Lowe. Just for clarification, any questions from your region on the platform? I gather that there aren't any. Then let's go over to the ZFM District Municipal Area, Mr. Zweni. Any questions or inputs from the members of the public at your venue?
Thank you, Mr. President. I have one input here.
To be by the purpose of the act. Ek wil net probeer verstaan, ons daar word 'n nuwe demarcation word established of kan ons input maak vir ons eie gemeenskap op hierdie ondersoek.
If you get the question, Chairperson. Can you hear me, Chairperson?
Mr. Zweni, you broke up a bit. We could not hear the question.
Yeah, Chairperson, I will ask the member to repeat the question. Maybe it was not clear to you. She's going to repeat again.
Thank you.
I just want to know on purpose of the act. Are they busy to establish a new demarcation board? And can we make input on our boards where we stay today?
Thank you. The question was audible. Are there any reactions from the department on this question?
Thank you very much.
That is the only input that we have from the side, Chairperson. Thank you.
I'm not sure, Chair, whether you've provided me a platform to respond.
You may respond. Thank you. Please just introduce yourself from the department.
Can I go on, Chair?
Sir, you're welcome to respond.
All right, thank you very much. Probably it's the network issue from my side. I couldn't hear the other way, Chair. I'm Mandile Kumar in that regard, Chair. And just to respond to the questions from the member, yes, this act will establish a new authority, but the current demarcation board now is currently undertaking municipal boundary and what the delimitation process is. So, in terms of this act, in terms of the current principal act, the board is required to consult the members of public when it delimitate the wards, their respective areas. So, of course, yes, the members of the public are more than welcome to engage the board and make their representation and views on how they feel the ward should be construed and be delimited. Once this new bill has been enacted by the President, probably during the right time, the new board will be ushered once the term of this current board will delimitate towards a municipal boundary determination using this bill that we are currently speaking about, rather than the principal act that is currently in operation. So I'm not sure whether I've responded to the question of the member, Dara. Thank you very much, sir.
Thank you, Mr. Kumalo. Mr. Zweni, could we get an indication for the record's sake whether the member of the public are satisfied with the answer given?
Yes, Chairperson, she said that she's satisfied with the response. Thank you.
Thank you, Mr. Zweni. Are there any other questions or inputs?
There are no questions from our side, Chairperson. Thank you.
Thank you, Mr. Zweni. Then we move over to the Pixley District Municipality. Mr. Manene, you are welcome to proceed. Are there any questions or inputs from the members of the public at your venue? Mr. Manene, am I audible? Can you hear me there? It seems that there's a. We're just going to contact him via phone call to make sure that he is still on the platform. If we can just have your indulgence for a minute or two. Thank you. I've been notified that there is a person on the platform, Mr. Gregory. Mr. Gregory, you are welcome to pose your question or make your input in the meantime.
Thank you, Chairperson. That I'm actually from now from the union. We've listened to the concern on the presentation now, Chair, is that the timing of the presentation and the setting today, it doesn't justify the means of it. We want to request that possible further consultations be done on the matter because we all know that we're on all Good Friday Eve and we don't have the broader role players here really dealing with the aspect as well that because the people are affecting in terms of when you start looking at your purpose as well and you start looking at the knowledge the rate of race now on the purpose and we start looking into much broader input from communities, it will just justify that if this community can rather look further taking this matter to communities where we can have much broader discussions on the aspect about as well, so that it must become inclusive as much as we can. Because end of the day that we are fearing the issue of legal litigation in the future that broader consultation hasn't been done. So that's a submission that now wants to do Northern Cape on the issue as well. Thank you, Chair.
Thank you, Mr. Gregory. Your noted on the platform and on record. However, my suggestion would be that you please put it in writing and then submit it also via the email to be considered. I thank you. Mr. Gregory, you are welcome to speak again. Okay, I've got an indication that his hand is not flashed anymore. Mr. Sandine Manene, are you able to communicate with us? We're still struggling to get a hold of Mr. Manene. Yes?
say. But with regard to the presenters or the other speakers, we can hear them very clearly. But in any case, there is no person who's having an input from PIXU with regard to the first presentation. Thank you.
Thank you, Mr. Lene. We do appreciate. Well, that concludes our deliberations on the Municipal Demarcation Authority Bill. And to continue with the rest of the presentation, I will then hand over to Honourable De Huys. Honourable De Huys.
Thank you very much, Honorable Jubed. Honorable members who have joined us on the virtual platform, members of the public across the 5 regions in the Northern Cape, and the members of Francis Bard region that are here with us in the legislature. Good morning. Honorable members and the public, members of the public, we will be dealing with 2 bills. The first bill, which is the Public Service Amendment Bill. That's the first bill that we'll be outlining. So in terms of this bill, honorable members and the members of the public, the Section 76 are bills that ordinarily affects our provinces. This bill was introduced by the National Department. The department gave a briefing to the permanent delegates to the NCOP, who in turn with officials from the National Department briefed the Portfolio Committee in the Northern Cape Provincial Legislature. The bill was considered by the National Assembly and referred to the National Council of Provinces for concurrence, and the NCOP in turn referred it to the provinces. The Public Service Amendment Bill is a bill that we will be dealing with at this moment. The reason for our visit on these platforms that we have gathered the province in this hybrid platform is to bring the legislature to you that will directly or indirectly deal with what is affecting our lives. Provinces are now conducting public participation processes in all 5 districts, namely your Namakwa, your Francis Bard, JTG, Pixley, and ZFM. To solicit your views and have an input in this bill. You may make written submission and submit and reach us by the 2nd of May, 2025. You can also get the information in our website. The 6-person delegation will, at the NCOP, take our position to these bills forward. You are expected to be clear with the clause you feel need to be revisited and give reason and propose the wording of the amendment. Members of the public, we are now going to take our first presentation, and the presentation will take 25 minutes. And I will urge our presenters and members of the public to be cognizant of time to allow for engagement. The stakeholder engagements will take 30 minutes, and then the 5 minutes has been allocated per region for responses. So I will be allowing this time to the Director of Public Administration, Norms and Standards and Evaluation, Mr. Kuben Govender. I would like to check if Mr. Kuben Govender has joined us on the virtual platform and is ready to make his presentation. Is he? Okay.
In attendance, our acting director general, maybe we can give him a moment to say a few things before we proceed.
Thank you very much, sir.
Thank you very much, Honorable Chair, and then Mr. Kuben. Yes, just to make a first statement on the preamble that presentation. I think one thing we need to appreciate the chair and the members in this attendance and civil society. I wish to thank the Provincial Legislature for allowing the legislature to present the content of the Public Service Amendment Bill in this regard, in preparation their absence for the improvement. I think it's quite important just to indicate that this process, unless I've been reached the bill, the primary objective of the organization
apologies, sir.
the capacity.
We are struggling to hear you. We are struggling to
Yeah, I
hear you.
know network is an issue. Well, I'm struggling from this side, from the other side. But
Can I kindly check?
Just to
Sorry, can I check with the members if members of the public if they are able to hear? Is he audible to you?
No.
There's a challenge with your phone, or you are far from your device where you're getting. If you can just...
Members, let me hand over to my colleague Kuben to start the presentation. I think we've got a challenge of network since morning in this session. Kuben, you may take the floor.
Thank you.
No, thank you, Acting DJ, and thank you, Chairperson. I have flighted the bills, and we are cognizant of the time given to us, so we'll stick within our time limit. Firstly, I will be presenting the Public Management Amendment Bill, which is before the National Council of Provinces for a mandate from the Northern Cape Province through its elected members at the National Council of Provinces. So let me thank the Honourable Chair, members of the Provincial Legislature, traditional leaders and members of the community. I will try to be brief. The Public Administration Management Amendment Bill is basically seeking to amend the Public Administration Management Act of 2014, which is our principal act. At the moment, Chair and members, this bill, or the original principal act, became operationalized in 2019. It has 20 sections. 13 sections have been implemented. 7 sections are remaining inoperative due to lack of regulation, difficulties in operationalizing them, and some requiring amendments. Hence the purpose of this amendment bill, to mainly operationalize the other areas of the principal act that needed some kind of amendments. So this bill, the main objective, as you see, it is to improve service delivery, to aligning our human resources, governance and related arrangements in all 3 spheres of government. Chairperson, maybe at the beginning, let me take the opportunity to explain the role of the Minister for the Public Service and Administration. The Minister for the Public Service and Administration plays the role of being an executive authority for the Department of Public Service and Administration. That minister also is the Minister for Public Service and Administration. In terms of the bill, public service actually is the national and provincial department, meaning where we are in Pretoria, all the national departments, and in all 9 provinces, there are provincial departments. Public administration, on the other hand, is an extension of the public service. It includes municipalities, and as well as in this act, it includes other organs of state and other what we call state entities. So I think I must explain that from the beginning. So the minister has 2 bills. The first one we're going to present is the Public Administration Management Bill, or the bill which is actually looking at amending the Principal Act of 2014, and my colleague Dr. Foromo will speak to the Public Service Amendment Bill. So there are 5 key areas we're trying to amend in this bill as a department. We are looking at these 3 spheres of government to make it more streamlined for human resources, for mobility and other reasons, and also for transfer and secondments of employees. We're also looking at clarifying and providing clarity on the issue of people doing business with organs of state. We're also providing for clarity on the constitution of the National School of Government, as well as trying to remove unjustifiable disparities across state institutions, and to bring about a better coordination of the mandating process for collective bargaining in the public administration without interfering with the role of labor and all the role players involved in these processes. So clause 1, Chair, is simply to deal with some definitions, which I already talked to. That is the definition of public administration, as well as I think I need to define what is an organ of state. In our original Principal Act, we talked about certain or public servants not doing business with the state, but there seems to have been various interpretations of what a state is. So it necessitated a definition to clarify what an organ of state is. And we will deal with that. Let me maybe deal with that now in clause 1. An organ of state, simply in the amendment, it is a national department, a provincial department, a national government component, a provincial government component, a public school, as contemplated in Chapter 3 of the Schools Act, a municipality, a public entity, or any institution performing a public function. So this definition will be clarified in a later clause as I go through it. Clause 2 seeks to amend Section 5 of the Principal Act, where it provides further for the transfer of employees between the public service, meaning national and provincial departments, and to municipalities and between municipalities. So transfers actually will allow for mobility of employees across the 3 spheres of government to wherever there is human resource deficiencies that are found to be existing, or where there is a need arise for a transfer, and where operational requirements necessitate the transfer. So in the detailed presentation was provided to the chair and the committee, there are clear criteria to allow for transfers, and those details are provided there. But the main reason for this clause is to ensure good governance and to enable the transferability of skills and resources where it is needed to allow for the state to function better. Clause 3, Chair, seeks to provide for secondments. So it actually seeks to provide that a secondment section provided in Section 6 of the Principal Act should occur only when it is operationally justified. So one cannot find that the secondments can happen just for the sake of happening, but where there is an operational justification. Even there in the detailed presentation, there are clear criteria that are needed that will actually are provided for what would justify for secondment. This ensures secondments do not result in deficiencies being created where a person is being seconded, or hamper service delivery within the originating secondment where the person is being seconded from. So clause 3, Chair, proposes the repeal of Section 7 of the Principal Act as the transfer of employees affected by the transfer of the functions across institutions is adequately regulated in terms of the Constitution. So this talks about repealing of the original act in terms of clause 3. Clause 4 provides, excuse me, my apologies. Yeah, clause 4 I was talking about. Clause 5, let's go to that one. So clause 5, Chair, seeks to amend Section 8 of the Principal Act, where it provides clarity on the definitions of the words or expressions to ensure easier interpretation, like I've mentioned in terms of what is an organ of state. So we clarified that an organ of state are given that definition from clause 1. But mainly, this clause, it also provides that certain employees are excluded from this particular clause. For example, people appointed ex officio on boards, on boards of state entities in particular. It also empowers the minister to determine which categories of employees are not construed as conducting business of state. That will be done through regulations. And for example, Chair, let me give an example of a category of employees. We have teachers, and at the end of the year, metric teachers are called to assist the state to mark metric papers, and they receive some kind of stipend and remuneration for their services to the state. Hence, this category, for example, will be not construed as doing organ with the state, and there is other categories that will be issued through regulations on clarifying this for implementation once these amendments are approved at some stage. So clause 6, Chair, this amendment is clause 6 seeks to address post-employment restrictions. Simply put, it is when somebody leaves the public service. So it is actually proposing that there is an imposition of a 12-month cooling off period for employees involved in procurement of services to service providers. This is all in the state. It provides for a prohibition from accepting employment or appointment to the board of that service provider, the performance of remunerated work, or receipt of any gratification from the service provider. The service providers or employees who contravene this provision are guilty of an offense and conviction liable to a fine up to 1 million rand. So this clause, Chair, just to explain, it is trying to prevent what we would call throwing the javelin. So we found certain categories of employees involved in the state, especially in the procurement value chain, in the decision-making value chain for issuing tenders, might issue a tender to a service provider and then resign after a short period of time, and then join the service provider and find benefit either financially or otherwise from that. So this clause is a very important clause. It actually restricts both the employees of the state as well as the service provider. Let me go on to clause 7. Clause 7 also seeks to clarify the current provisions in respect of the definitions of employees for the purposes of disclosure of financial interests. Now, as you're aware, Chair, there are different categories of public servants who need to disclose their financial interests. As we speak right now, we senior management and government for the month of April have to declare all our financial interests. How many cars we have, how many properties, how many shares we have in any companies, how many directorships of companies we might have, amongst others. And there is a process to screen and to check that. But what we found in the original Principal Act, we used the term officials, and we're now dealing with defining what an employee is to clarify that all officials have to disclose this, and there is a process for that. And there are regulations and directives issued by the Minister for the Public Service and Administration, clarifying and assisting departments on how they must implement this. This clause also includes, Chair, from the Principal Act. Yes, sir.
We just had a challenge. The agents are indicating that they can't hear. We're trying to establish if whether it's your volume or is it something technical that needs to be attended to here.
You want me to pause, Chair?
Yes, can we just pause and then let's establish what could be the challenge.
Noted, Chair. Thank you.
Can we check with Regents, Mr. Sweni, can you hear us in ZFM? Namako, Mr. Lowe, can you hear us?
Yes, Chairperson, you are audible.
Okay,
we can hear you.
We're fine. Did you hear the presentation? Was the presentation audible?
It's very clear, Chairperson.
Okay. ZFM? Clearly ZFM is not audible. Can we check with Pix? So we've got Namakwa, we don't have fixed and ZFM.
Chairperson.
From Pix?
Speaker.
ZFM. Okay, so ZFM is fine. Pixley?
Pixley is fine, Chair, with the presentation I can hear. But the only problem or challenge that we have is when you or anyone from the Ruth First is speaking, then we can't hear properly. But in terms of the presenters, we hear that properly. Thank you.
Okay. So what is important is for them to get the presentation. There's an indication that they can hear the presenter. Yeah, Mr. Governor, can you continue, please?
Thank you, Chairperson. Let me maybe repeat. I was on clause 7, yes. So clause 7, Chair, seeks to clarify the current provision in respect of the definition of an employee of the state, meaning in all these categories that I mentioned of the state, who is the employees, and is also for mainly the purpose of disclosure of financial interests in terms of the directive that was issued by the Minister for the Public Service on declaration of financial interests. It also goes to include a person appointed to advise the executive authority. In the Principal Act, advisors to ministers, deputy ministers, or other executive authorities were excluded. So this clause 6 to include persons appointed to advise the executive authorities. Clause 8 seeks to amend Section 10(2)A of the Principal Act to provide that departments must, within their available budget, provide for compulsory training that is declared or directed by the Minister to address developmental needs of categories of employees of the state. So, Chair, just to explain this area, the Minister of Public Service and Administration will issue regulations to state that after working with the different role players to identify what are the key developmental needs for certain categories of workers in the state or employees, and then declare it compulsory. For example, just to give the committee and members of the public an example, if I was as a deputy director in government and I want to apply for a post at a director level in government, I need to do a compulsory training through the National School of Government, which is called a Nuclear training, to also pass it, and that must be a prerequisite for my appointment, if I am appointed, that is, to a senior management level, that is, a director level in government. It's a typical example. There is so many other examples that for compulsory training, and there are categories of that for specific workers. Clause 9, Clause 9 seeks to amend Section 11 of the Principal Act to establish the National School of Government as a national department and to provide education and training for public service or employees for all three spheres of government, including municipalities and public entities. So basically, this is a clause that is retaining the current situation that the National School of Government is a national department as opposed to a training institution. It has those training capabilities. It has a model where it works with other training institutions to provide training for employees of the state. But this clause also now extends it to the municipalities, as well as if the public entities are also requiring training from the National School of Government. Just to also mention, Chair, that some provinces have provincial schools of government established to provide training at a provincial level. Let me go on to Clause 10. This clause seeks to repeal Section 12 of the Principal Act as it has become redundant because following the proposed amendment that I just mentioned. And Clause 12 of the Principal Act dealt with higher education and training, which is now dealt with by the National School of Government. So this is just an amendment because in Clause 10, we're talking about proposing the National School of Government being a national department. Clause 11 seeks to amend Section 13 of the Principal Act to remove the unnecessary burden placed on Cabinet in relation to the determination of prerequisites and mandated training and education and training. At the moment, the Principal Act talks about Cabinet approving these mandatory training. Now it is now a responsibility for the Minister for the Public Service and Administration. As we have seen, the program of Cabinet is extremely tight, and they are dealing with various other strategic matters of the state. This one will be dissolved, or proposing it be dissolved, to the minister who is responsible for that function. In any case, as the National School of Government principal reports to the Minister for the Public Service and Administration. Clause 12 provides for a deletion of section 16(2) of the Principal Act. Therefore, the process to issue norms and standards in respect of the promotion and values and principles contemplated in section 195 of the Constitution will be in terms of the processes contemplated in section 16 of the Act through making regulations. Chair, let me just explain this also with your permission. The Minister for Public Service and Administration has powers to issue norms and standards in terms of Section 3 of the Public Service Act, as well as Section 16 of the Public Administration Management Act. So in this Act, the Principal Act, the Minister can issue norms and standards or may provide minimum norms and standards to the promotion of values and principles, capacity development and training, information and communication technologies in public administration, integrity, ethics and discipline, disclosure of financial interests, measures to improve effectiveness of the state and efficiency of the state, disclosure of information relating to pending disciplinary action and concluding of disciplinary proceedings, and any other necessary matter to give effect to the administration and the implementation of this Act. So in that section, what this Act is, this bill is proposing that the Minister now will issue regulations around the promotion of values and principles, because the original Principal Act talks about after consultation, which becomes almost impossible to consult with all institutions in government. I'm about concluding, Chair, with your permission. I've got about two more. This clause 12, provides for the deletion of section 16(2) of the Principal Act. Therefore, the process to issue norms and I talked about that, my apologies. Clause 13, we are now. Clause 13 seeks to amend section 17(7) of the Principal Act to remove reference to and its members. Now, let me explain this. Clause 13 of the Principal Act states the Minister for Public Service and Administration, in terms of section 17(7), may proclaim the powers of this Office of Standards and Compliance and its members. So this clause is saying there's no need to give powers to the members, because once you give powers to the office, it indirectly gives powers to the members. So there's no need for individual members' powers in executing the mandate given by Section 17, though there are 6 key objectives of the Office of Standards and Compliance. But Chair, the main key objective is to ensure compliance across all 3 levels of government. And there are various other powers issued, including the office having its own regulations, which are giving the office its powers to execute its mandate. Clause 13, Chair, that was almost the end of Clause 14. It provides for an insertion of Section 17A and Section 17B of the Principal Act. This tries to deal with the unjustifiable disparities in relation to employees who do not fall into the scope of the relevant bargaining councils. I'm happy we see members of Labour Federation and Movement are part of the meeting. This is not to interfere in any way with the bargaining council's roles and responsibilities as given at the present moment, but it's also assisting those which are not part of the bargaining council chamber mandate. You will know that level 2 to 12 category of workers in government falls under the bargaining council. So to this end, whichever other category that doesn't fall there, we are trying to deal with managing that area of that category of employees. To this end, this bill provides for the minister, after consultation with the relevant minister and subject to the processing of regulations, to prescribe upper limits of remuneration and conditions of service for certain categories of employees who do not fall into the scope of the relevant bargaining councils. All those other categories will be managed through the bargaining chambers, which are the PSCBC and the GSBC. So if this amendment also, Chair, establishes a committee of ministers which must, it says must, in determining a mandate, take into account affordability and any other factor prescribed by the minister in consultation with the Minister of Finance. This provision is basically aiming to create a better integration and coordination between various institutions to remove unjustifiable disparities without eroding existing collective bargaining structures and processes which determine or undermining any prescripts governing employees in various institutions. The bill actually further goes to recognize the role of premiers in provinces, deputy ministers, organized local government, SALGA, and creates an integrated intergovernmental forum to ensure that such parties are consulted in these processes. So in a nutshell, Chair, this is an amendment proposed to strengthening the bargaining process in terms of managing the wage bill, which is one of the core responsibilities of the employer, which is the Minister for the Public Service and Administration. And it doesn't seek to amend any other processes, as I've highlighted and I've stressed specifically on this to ensure no misunderstanding. It actually extends to give even consultation to SALGA, who is a recognized local government organized labor, because it will now deal with salaries across all three spheres of government in future if the bill is passed. Finally, Chair, and thank you very much for your indulgence and your patience, and my sincere apologies for those who could not hear. Through the hybrid is always a difficult platform, but it's something that we need to get used to because COVID has made this necessary. Clause 15 is just about, it seeks to amend Section 18.2 of the Principal Act to align Local Government Municipal Systems Act regarding the issue of regulations pertaining to local government after consultation with the minister responsible for local government. So this is another very important clause because we had to, through the Public Management Amendment Bill, also look at aligning the Local Municipal Systems Act through this act. The Minister responsible for finance and local government. Additionally, a further amendment is proposed to allow for making of any regulation affecting public entities to be made after consultation with the minister responsible for the public entities. So, Chair, the Public Administration Management Act bill, in a nutshell, it was originally seeking to realize the vision of government to have a single public service. But during the processes of this bill was passed in 2014, and now going through a process which you are going through now for provinces' input for amendments, and we have two bills. It originally wanted to have one bill, but eventually Parliament decided to keep the bills, both the Public Service Act as well as the Public Management Act, as two bills to empower the minister responsible for the public service and administration to actually manage his or her responsibilities. I will now pause here, Chair, and stop and take any questions. Thank you very much again.
Thank you very much, Mr. Governor. We are now going to allow our members of the public from all our 5 regions an opportunity to ask any question or make their inputs and submission, and other sectors to have their engagements. We are going to start with Francis Bard here with us. And let me just make this submission that we are going to take your inputs as the public, as members of the public from across the districts, and we will allow the departments to give their responses after the 2 presentations. So I'm quickly going to check in Francis Bard if there's any submission or any input or any question that you members would like to make. I've got a hand there.
My name is John Lowe. I'm from the Magare municipality in Warrenton. My first question have an impact or try to find some clarity on this matter of deployment of teachers during the elections. There's something that there's not sufficient clarity on this matter, because now we amend an act and it's silence on the deployment of teachers during elections as presiding officers. My second one is the declaration of interest. I've picked it up in some of the clauses where they talk about the tender system in the municipality. You got the 3 committees, your specifications, adjudication. I think this is evaluation and adjudication committees. And these committees are chaired by employers of the municipality. But for the time I was a councillor, during my time, I never pick it up where an item or a report come to council which, like the municipal, the code of conduct for councillors, which you have to declare any rewards in anything, directorship or whatever in any company. But unfortunately, for your levels of management in the municipality, we never had such a thing where we can see through the chairpersons or members of the communities have a declaration of interest. You just, they are going there, sit there, do it, because councillors are bad to be members of the, let me tell the tender bid committees. My final one, I have 3, but maybe I have forget the final one. Yeah, the final one is on the Municipality Systems Act. Now I've picked it up that you try to align the Public Service Act with the local government space, where we talk about specific on the Municipal Systems Act. And now you'll find out that the Municipal Systems Act are currently very silent on public service, members of the public service. When we come especially to the norms and values, like your Batupele values, really we find ourselves in an environment at local level, at the municipality, where there's no such a watchdog. You got the MPEC, Municipality Public Finance Committee, but you never have an oversight mechanism, like in your Public Service Act, in the Municipal Systems Act. And also councillors are not part of such committees in your municipality except to be chair of a corporate committee or chair of other committees. But unfortunately, we have a lack of a watchdog. But now when you align the National Public Service, the PSA, when you align it with the local municipality, then which means the community must also be allowed to make presentations so that we can maybe try to save these communities and see that they are functioning. This is my 3-day chair. Thank you.
Thank you very much, Mr. Lowe. Do we have any hand?
My name is Jan, J-A-N.
Jan Lowe.
Jan Lowe, L-O-U-W.
Okay.
Quality.
Thank you very much. Do we have any submission? We've indicated that we will be also taking all your written submissions to be submitted before the 2nd of May.
Mine is just a concern. Ke tla tloba ka leleme la ga mme. Monna Stilo, matsapa ka ke gore in my concern.
Good morning, I'm going to translate for him.
Okay, Lina la ka ke lebogang Tlhole from Magareng municipality.
From Magareng municipality.
Matsapa ka ke gore
My issue is that
re tla mo di billing tse leng gore at the end of the day re santse re di votele.
we come here to submit bills that we have to vote for at the end of the day.
So ke fula gore go na le mongwe o sa direng mmereko wa gagwe sentle.
So I feel like there is someone that isn't doing their job properly.
Because like now re ntse re le mo public service bill.
Because currently we are at the public service bill.
E tlhokang gore at least nkabe re kry-ile batho ba e leng gore they are in public service.
That needed us to have people that are in public service present.
Ba ba understandang gore this bill ha re re e hate goreng re re e hatisiwe.
Who understand why when we submit or say that the bill should be passed.
Because some of the amendments tse di tlhagellang mo at least o santse o bona le an experience ya tsone to say why am I agreeing to this?
Because of the amendments presented currently, there should be someone who has experience to say why these things need to be submitted.
My other concern is this one. Refiwa nako ya gore engagement in only 5 minutes.
My other issue is that we're given time for 5 minutes for the engagements.
I once said it, Parliament, it 3 minutes. Why are you coming to us and then you limit our time?
When Parliament once arrived, they said that they'll give us 3 minutes to engage, but I want to know why are we being given a time limit?
Secondly, I will now challenge the legislatures to say, if Renaldi bills it's di bua too much ka di acts like this, and as certain bills will declare romela mo goreng a certain act more constitution of South Africa it says what, but then we don't even have Wi-Fi's telling gore dia bereka so that ha re bona a certain clause e re 1 2 3 e romelang to a certain constitution e buang ka act mang so that we must be able gore re shebe mo gone gore e reng.
Okay, I want to secondly challenge the legislature to say that there are a plethora of acts and bills, but where we are situated or where we live, we don't have access to Wi-Fi or internet, so we can't thoroughly go through the acts or bills and then contribute.
Ke a leboga.
I thank you.
Thank you. Thank you very much. Can we then move to there's a hand. Okay.
Good afternoon, Chairperson. My name is Thomas Kawoko from Pogwane. Chairperson, my question is just simple. My question is on clause 9 of the National School of Government. Chairperson, my proposal or my inputs on clause 9 of the National School of Government was just to check, Chairperson, if the certificate, the CPMD certificate, Chairperson, for the municipalities, can it be incorporated into the National School of Government? Because if you look at the CPMD, Chairperson, it's ranging between 60,000 to 85,000 per person, Chairperson, whereby a municipality has to fork out that money. If you have to take 10, if a municipality has to take 10 employees for that certificate, Chairperson, it costs the municipality almost 600 to 1 million rand, Chairperson. Whereas, Chairperson, the National School of Government registration is about 400 rand, Chairperson, and then you go through those modules, which I think they are more similar than the CPMDs, Chairperson. So if this amendment bill, Chairperson, can incorporate the CPMD into the National School of Government, Chairperson, I think one of our municipalities will be able to save a lot of money. Thank you, Chairperson.
Thank you. Can we check with other regions? Can we start with ZFM? Can we get an indication from ZFM? Okay.
Very important. And the way the presentation was, I would like to myself, if I'm saying I'm happy with the presentation. We even didn't have a hard copy where we can read and see things. We even can't read on the board where the presentation is. So for me, even service delivery is important for all of us. And sometimes people think service delivery is only a problem, to say councillors is a problem, but it's not. There is a lot of facts which is leading to service delivery. And we can't have a presentation like this. So how will I report to my, the persons who sent me to this presentation? So even the last one is the last one. If we see some people as leaving the room. So the other question is, why did they not send someone who represent to us this first? I know that what is this thing? Technology is important, but in the Northern Cape, I think it is important for us to send someone representing these things to us, because even if we belong to different political organizations or any other organization. Service delivery is for everybody, not for. So I'm not happy with the presentations. Thank you very much.
Thank you. Can we check with Namakwa? Oh, sorry. Can she kindly reintroduce her name from ZFM? Okay, from ZFM, can the first speaker reintroduce herself for the purposes of record?
Good day, Chair.
Yeah, there's someone here from ZF once more, Chairperson.
Good day, Chairperson. Chairperson, my name is Councillor Salim Langs. I just want to agree with the previous speaker because here in our auditorium, you guys are not audible at all. And it is affecting us very negatively because people are busy doing their daily things whilst we want to listen. We seem to struggle to hear what you guys are presenting to us and what the other people are trying to give, the inputs that they are trying to give are not audible. So we do not understand where we are actually, because we would be repeating stuff that has already been said by others that maybe got a chance to speak. I would also like to agree with the suggestion that you send somebody that would come here and present all these bills to us in person, because previously when you would send somebody to us, the halls were filled and we had a very good interaction and we could give our presentations and inputs to maximum. But today, really technology has failed us and we are lost here in ZFM. I thank you.
Thank you. From ZFM. Can she kindly reintroduce herself? Or we'll get it. Okay. Yes. I can
There's an
hear.
input from Pixie.
Okay, it's Mr. Sanem.
Okay. Thank you. My name is Dumelo Fas from Pixley region. I would like to concur with the two previous speakers that we are also kind of experiencing problems with the hearing and the presentations from the speakers. So I would like to agree with them as to say that these public hearings should be done physically, whereby people would be explained to in even the languages they understand, because now there is absolutely no engagement because hearing is a problem. To others, the language is also a problem. Thank you.
Thank you.
Chairperson, we've got someone from Namakwa as well.
Namakwa. Yes, you may proceed.
Goeiemôre. My naam is Brian. Ek is van die Namakwa region. Om net aan te sluit by daardie vorige persone wat met u nou gepraat het. Ons sit nou al vir meer as 2 ure. Sit ons nou al in die virtual meeting. Maar om die waarheid te sê, die goed wat vir ons deurgegee was, is so vaag en onduidelik dat ons weet nie actually waaroor die virtual meeting gaan nie. So ek sal saam met daai persone stem om te sê dat virtual meetings moet physical meetings word, sodat ons mekaar kan fisies sien. Want die goed word vir ons baie onduidelik ook deurgegee en dan moet jy net aanvaar en saam met dit gaan. So ek sal voorstel dat daar datums gekry word sodat ons beter en meer ingelig kan word rondom waaroor dit goed gaan. Want dit word vir ons afgelees en ons moet dit maar net aanvaar. So ek sal voel dat dit op 'n regte manier gedoen word. Baie dankie.
Dankie.
Thank you.
Where? Okay. You may proceed, Mr. Gregory.
Mr. Gregory, you are muted.
Because of time, can we check if there's any other hand that is up there? And then we'll come back to Mr. Gregory. Or we move to the next region. Check with other regions if there's any question or submission they would like to make. In the absence of any hand, I assume our members of the public are all covered with their submissions. We can now give over to Mr. Governor to make his responses, to respond to all the questions and submissions that have been made. Mr. Governor.
The members of the public that have raised the issues. From my side, as the department, majority of the issues are targeted to the committee, and many of them should be noted. But let me also clarify a few areas that I can come in. The first speaker raised the issue about teachers during the election periods. The elections, Honorable Chair and members, are run by the Independent Electoral Commission, and they have specific criteria for selecting people to assist during the elections. This is one of the categories that will be exempt from the category of doing business with the state. Because when people are volunteering during the election, they are assisting government and an independent institution set up by government to conduct the elections. But the issue of teachers can be an input that can be noted by the committee in the report and in the submission, because I guess the member is raising then when the teachers are there, who is then teaching the children? I assume that is his concern. So if I got the understanding correct, then maybe that should be a submission that should be included. The issue of the municipalities and an alignment and so forth from the first member, this is exactly the main intention of the Public Administration Amendment Bill. It is actually trying to resolve some of the things that the first speaker has actually mentioned. that is ensuring that these Batupele principles, these norms and standards that are set nationally for the whole government, should be implemented in all three spheres of government. But remember, Chair, we are very cognizant of the fact that all three spheres of government, while we say we're wanting to ensure compliance of certain norms and standards across three, we are very cognizant that the three spheres of government are independent, but yet highly integrated and interrelated. So we are trying to resolve some of those matters, even from the concern of the first speaker, by this public administration management bill, by actually allowing for the engagement of the Minister for COCTA, the organized local government, as well as the Minister for Public Service and Administration, to try to work together, consult with each other, and try to resolve to get some form of uniformity across the three spheres of government, especially on the issues that the concerned first person has raised. Chair, from the rest, it talks about setting up an oversight mechanism for local government and also communities to be allowed. Those are more submissions to the committee for the consideration, and most of the other issues raised by all the other speakers are things I would say are more for the committee to note and maybe to respond. I thank you very much, Chair, for this opportunity again. If there is any other clarity, then we can take it later. Thank you.
Thank you. We'll go to the next. Thank you, Mr. Governor, for your engagement and your presentation. We'll then move to the next presentation that would be done by Mr. Dr. Robert Foromo, who will be dealing with the Public Service Management Bill. Dr. Foromo. Okay, before we give over to Dr. Foromo, ZFM just indicated that there was a question there. I don't know, was it that time when they were struggling to come back to us? Can we just afford them an opportunity to pose a question? And Mr. Governor will immediately respond to it. Can we have all our questions consolidated as now? Can all our regions consolidate all the questions there before we hand over? Because we don't want to leave anyone behind. A follow-up.
Mora, Chairperson, Ratslat Komazi. I just want to ask, suggestion. Can we close because ons kan niks worry. Dat die LP ons gaan voort. So kan ons maar close asseblief. It's a first, yeah.
Can you hear me? ZFM? Am I audible in ZFM?
Hi Chairperson, ons is van die Richtersveld, municipaliteit na Makwa area. Ons vrou kan ons maar afsluit van wat hier aangaan kan ons ook nie uitmaak. And I thank you.
We can hear them, but I want to check if the challenge they're having is that they can't hear us. Can I do this? Can I check with ZFM? ZFM, did you hear the presenter when he was making his presentation and when he was making his responses? Because I assume that the regions had the presentations because they were able to engage on the very same presentations. So I wanted to check what is the main challenge and which region can safely say they couldn't hear the presenter and they can't hear us. Can we start with ZFM? ZFM, can you hear me? Have you heard the presenter? Have you heard both the presentation and the response?
Well, we can read where they are talking about the bills and everything, but when it goes to your chamber, then we can't hear anything that's coming there from that side. So in Namakwa, that is very poor.
Okay,
You must assume.
So Namakwa can hear me because they just responded to what I just said. I assume they couldn't hear Francis Bark when he was making their own submissions and inputs. Yes. Namakwa. Okay, ZFM. Can we call make calls for ZFM and Pix and check if they capture everything? I don't know about JTJ. Yeah. So now ZFM. So this means ZFM cannot hear us anymore. But they just responded to what I was saying. Pixley. Or they should rather say we are losing them. Maybe they can hear us and then after some time they can hear us. I don't know. ZFM. Namakwa.
Can you repeat the question?
No, I was just trying to establish if whether you were able to get the presentation and its responses.
The presentation on the screen is fine. What is happening is that the presenter, those that were presenting from Pretoria, you can hear them. The problem is that when the chairperson speaks at from Ruth first, that is the problem. We can't hear you clearly. There's an echo. We can hear what we are saying. Sorry, we can't hear what we are saying. We can hear that someone is saying something, but we can't hear clearly. But the presenters, those who are presenting from Pretoria, we could hear them. And the presentation, we can see the presentation, but it's not clear. It's not that clear enough. Now the request that that we're making is that in the future, instead of having the virtual or hybrid public hearings, let's have them in person where we have people in the venue so that they can interact with those people and they can hear clearly because they can't hear currently. That is it, Chairperson.
No, thank you very much. I think the request that we can all concur with is that in future we need to have an in-person session where we will not experience so much technicalities due to the vastness of our province and our connectivity. But what is important for today is that the presentation was audible, they could get the presentation and they could make their inputs. What we seek to achieve is to get inputs from members of the public and to get their submissions on those bills. So for me, it's not much of a factor whether I was more audible or not. It's just to facilitate the meeting. But if the presentation was audible and the presenters were able to respond adequately and sufficiently, that's what we should, for now, be satisfied with. And then in future, we note the request that we should go to our people in person and make our presentations. So thank you very much, members of the public. I don't know if the hand that was from ZFM was to raise the very same issue of not able to hear me, but in the absence of any hand, can we then move to the next presentation that would be done by Dr. Foromo on the public service management bill? Dr. Foromo.
As everybody can see the presentation on the screen.
No, it's not flagged on the screen.
Can you see it?
From ZF, the members are saying that the presentation is there, but it's not clear. They can't see it on the screen. They can't, it's very faint. They can't read it.
Yes, we are trying to flag the new presentation, and then you will then indicate if whether it's appearing. This is a previous presentation. We are now going to the next presentation, and we want to check if it's there.
So, Chairperson, can everybody see what is on the screen so that I can continue to present? Can I get an indication?
No, nothing.
Okay.
It's the old one.
Nothing.
Previous one.
You can't see it?
No. And we need to have it because they've been following on presentation
It's
in
not the
case
old
they
one,
can hear
this
you.
one. Mr. Governor, can you stop sharing there? This is not the old, this one is the Public Service Amendment Bill. It's not the Management Bill. Kuben, did you stop sharing?
Yes. Move your presentation to the beginning and scroll it down.
I see, so that people, they can see from the beginning.
Yes.
This is the Public Service Amendment Bill that I'm presenting, Chair. And then, Chair,
it's
what
there.
I'm going to do, can you see it?
Yes. Let me check with the regions if they can see it. Because from our side, we can see it. Can we check in ZFM? Can you see the presentation there in ZFM? So, because they're struggling to hear me, I would propose that one communicate with them.
This is Manene at Pixley. I made copies, so we are fine at Pixley.
Oh, okay. Thank you very much. And ZFM? Namakwa?
Chair, the presentation can be seen, yes.
Thank you very much. Can someone check with ZFM because they are the only one not responding now, if the presentation is flagged on their side? Okay. No, thank you very much. You may proceed, Dr. Foromo.
Okay, can I continue, Chair?
Yes, please.
Okay.
Okay, thank you. Colleagues, this is the Public Service Amendment Bill. It was first enacted in 1994, and subsequently it has been amended based on the new development. So due to the times that we were given, I'm going to stick on the summary of the bill, but from the top where I was from page 1, it is the whole bill which I hear that colleagues were given the copies. So these bills, its objective is to provide for the devolutions of administrative powers of head of departments and to augment the role of the Director General in the presidency to support the president, and also to provide an alternative mechanism for the recovery of overpaid remunerations and benefits which were wrongly paid to an official, and also to clarify the role of the Public Service Commission in respect of the handling of the grievances in the public service. And also we clarified the role of the President and the Premier in the appointment and career incidents of the head of departments. So clause number 1, it talks about the definitions which were amended. It seeks actually the definitions which amended is the executive authority. Executive authority in terms of the national departments and the national government's components, it referred to be as the president of the country, and that the head of the office of the premier and a provincial's department, also provincial's government component, it refer as the premier. So the executive, in terms of the nationally, we refer it as the president. In terms of the executive authority, in terms within the provinces, we refer to as the premier. And then the other definitions which has been amended is a head of a department, it referred to as a head of department as contemplated in sections 3A. And also there is a new definition to which it was not there in the Act, which is, we call it a political office. And then a political office, it referred to as the chairperson of a political party or a deputy chairperson of a political party, or a secretary of a political party, a treasurer of a political party, as well as their deputies. So any positions in the party equivalents to a positions referred to in the paragraph A, irrespective of the titles designs to a positions. So a political office is a new definition which it was not there in the Principal Act. Therefore, in this bill which we're amending, we are inserting it. And then clause number 2, it seeks to substitute sections 3(7) of the Principal Act, which regulates the powers and the duties of the executive authority. And also 3(7) Principal Act was redrafted to provide the strategical powers to the executive authority. In this case, the executive authority, from our definitions, we actually was mentioned it. And the necessary checks and balance for the delineations of these powers between the executive authority and the head of departments has been provided to ensure accountability. And also clause 2, which is 3.2.2, it further provides the executive authority with the powers to intervene in the event if the HOD fails or refuses to fulfill the powers or the duties in terms of this act. And also it devolutions of administrative powers from the executive authority to the HOD means that the executive authority can no longer have the powers to withdraw delegations, and therefore necessitate a process to allow the executive authority to intervene where it is justified. And then sections 3 of this act, it seeks to amend or to include the HOD and to provide for both the executive authority and the head of departments to deal with any matters that arises or which may arise from the employment or condition of services of a person formerly employed in the public service. And then clause number 4, in short, it seeks to provide section 7.3a for the head of departments to report to the executive authority as and when required, and also to assist the executive authority in fulfilling the executive accountability and responsibility obligations as contemplated in sections 92 of the Constitution. And also it implements the strategic plans, which actually it is part of the executive, is part of executing the responsibility. Also for 342, it seeks to amend section 7 of the Principal Act to provide additional functions of the Director General in the Presidency to align with the NDP objective that create administrative head of the public service to whom the DG in the Presidency will report on operational, organizational, and administrative matters. Then section 5, it seeks to amend section 9 of the Principal Act to provide the HOD with authority to appoint a person in the department. The devolutions of this power is to ensure the alignment of the financial responsibility with the human resources administration functions, which enable the executive authority to focus on providing strategic and policy directions. The previous act, these responsibility lies within the minister or the MECs. Now this clause, it says, can we take those departmental functions and then we align it within the functions of the HODs. And then clause number 6, it seeks to amend section 13 of the Principal Act to provide a head of department may appoint an employee on probation for such period as may be prescribed. These devolutions, also, these are just the new amendment that we're saying. We are taking the administration functions of appointment, which it used to be done by the executive authority. We are saying the HOD can be given the powers to sign and make that appointment, and also to approve if an employee has completed the probation period. Then clause number 7, it seeks to amend section 14 of the Principal Act to provide the HOD with authority to transfer employees within a department and to other departments. This function initially, it used to be done by the executive authority. Now this clause 7, it says, may the HOD be given that powers that can transfer employees within the departments or to other departments. Then clause number 8, also it seeks to amend section 14A of the Principal Act to provide the continuations of employment when a person who is already employed by an organ of state is appointed in terms of section 9. So this wants to say, may we recognize the continuation of services, that one does not need to actually resign where you are working if you are employed. If you were working in the organ of state, now you get a post in the departments, may you get that an opportunity for continuations of employment. Now clause number 9, it seeks to amend section 16 of the Principal Act, which deal with the retirement and the retention of services. It is proposed that the term officer be substituted with the defined term an employee. This one is a matter of English that we are moving the term called an officer, then we say it's an employee. And also it deals with the retirement and the retention of services of an employee. It further proposed that it seeks to provide the power of the HOD to authorize an employee to retire from the public service before reaching the age of 60. The current act It allows employees that you will retire at the age of 65, and then if there is no any other mechanism in place, you cannot retire at that age of 65 or 60 before you reach it. But this one, it says, can the HOD be given that authority to consider to approve if somebody wants to retire before the age of 60? Probably maybe from the age of 55, you may request to retire. So we are saying, may the DG be given that functions to authorize it. Initially, these powers, it used to be authorized by the executive authority. And then clause number 10, it seeks to amend 16B of the Principal Act to prohibit a HOD from agreeing to a shorter notice period for resignation, instances when an employee wishes to resign after notice of disciplinary hearing was given against an employee. So this act, we are saying the current employee says, if probably I am in a disciplinary hearing and it is not yet completed, and then I could see that I'm going to lose the case, so I may give 24 hours notice and resign. So, and the HOD or the minister cannot stop me to resign because the current one, it gives me this power. So this new one that we're amending, we are saying, can we give the HOD to prohibit, to stop agreeing that you will give this short notice until the finalizations of the disciplinary hearing is completed. This is, I think, is to promote accountability and responsibility of every employee within the departments, that if I have committed any unethical behavior in the departments and I could see that I'm going to be dismissed, I can just run away before the conclusions of the disciplinary hearing. Then clause number 13, it seeks to amend section 17 of the Principal Act to provide the HOD with the power to dismiss an employee. Currently, the HOD does not have the power to dismiss an employee. This power, it resides with the executive authority, the MEC or the minister. So now this clause, it says, may this power be moved away from the executive authority and be given to the HOD to dismiss an employee if there is a need. Clause number 12 seeks to amend section 30 of the Principal Act to provide that no employee shall perform or engage himself or herself to perform remunerating work outside of the employment in the relevant department except with the permissions of the HOD. The current regulations, it says the employee, if you want to do any other work outside of what you are employed, you need to apply from the HOD, and then if it is not if your application is not responded within 30 days, it shall be taken as it is approved. So now this one is to say, may the HOD try to look if an employee, it says, provide that no employee shall perform or engage any work, remunerating work outside of the departments. Clause number 13, it seeks to amend section 31 of the Principal Act to allow that the HOD, in exceptional circumstances, to approve the paying out of revenue an amount equal to that salary, allowance, fees, bonus, honorarium, or a portion thereof to an employee. The reason behind that, it says the devolutions of these powers to ensure the alignment of the financial and HR functions which enable executive authority to focus on providing strategic and policy directions. The current act doesn't give the HOD these powers. So this one, it seeks to say, can the HOD be given powers to give and payment, to approve payout of revenue and equally to that salary allowance. currently we don't have these powers. So the HOD, this one is saying, can you give the HOD to do those powers? And also it seeks to amend technical amendments to sections 31A of the current act to take into account the concept already defined and to correct the reference to sections 30B. Now, sections 14, clause number 14, it seeks to amend sections 32 of the Principal Act to provide the following: that a head of department may direct employees to temporarily perform other functions within the department, and an executive authority may direct the HOD to temporarily perform other functions within the department. An employee may be appointed to act in a post in the relevant departments by the HOD or an employee occupying the post. And the executive authority may appoint an employee to act as the HOD after consultations with the president. I think the last one is more on the national departments. The minister will consult with the president, and then in the provincials, governments, the MEC will consult with the premier to recommend or to appoint an employee to act as an HOD. And then these are the new amendments that has been sought to amend and to give the HOD that may have the power to temporarily to direct an employee other than what you have been appointed to temporarily go and perform other functions. And that's what this clause number 14 says. And then number 15, it seeks to amend sections 35(5) of the Principal Act to provide the minister of the DPSA shall be responsible to determine the procedure to be utilized when employee refer grievances within the departments. This is the internal processes, which may say, can we allow the DPSA minister to be responsible to determine this procedure to be utilized within the department. And then section 16 of the bill, it seeks to insert 38A of the Principal Act to prohibit a HOD and an employee directly reporting to the HOD from holding political office. The term political office has been defined to reflect the decision-making equilibrium of political parties. I think this one is, remember when we said in clause number 1, I said there is a new definition which is political office. So now we have inserted that definition. But in this clause we are saying the HOD, let me read it until we finish it. So the purpose of this prohibition is in respect of the HOD and the employee directly reporting to the HOD of the department from holding office in a political party, is to ensure that there is a clear delineations between the political and the administrative role and responsibility for the HOD and the influence employees reporting to the HOD may in the department. But this provision is limited to only to HODs and those employees who are directly reporting to the HODs. And as these are responsible and administrative decisions. So in other words, what we are saying if the HOD and the employee reporting to the HOD, they happened to hold a political office, so these people, they will be prohibited to hold two positions. You cannot be a chairperson of a political party or a secretary or a treasury or deputy of all those people, and then you also become the HOD. The reason for that, we are saying we need to align to promote and alignment of political administrative. Currently, the NDP, it's saying there is an unevenness of politically administrative. So in other words, there is this conflict. There is a personal conflict that if one, it is the HOD, and you are also become a chairperson of political party, there might be a conflict of interest when you execute your duties within a department. And also, if there are people who are directly, but they are employees, but they are holding those political offices, they may, especially if the HOD, it is not a chairperson, but the person who's reporting to the HOD happened to be the chairperson of a political party. It might be difficult for the HOD to discipline this director who is reporting to a HOD, but this director happened to be a chairperson of the political party, because the chairperson of political party in other organizations, they've got more powers than those one who does not have those things. So we are saying we should not actually allow people to have this. You cannot have a political office and you also have a positions of power in government. And then Section 17, it says it seeks to amend Section 37 of the Principal Act to permit the HOD, if it is allowed by the regulations, to the extent prescribed, to grant an employee salaries higher than the minimum amount of the appropriate salary levels of the applicable salary scale, or grant them a special advancement in salaries within the salary scale applicable to them, and grant them a salary in accordance with a higher salary level or any other reward, if they have an exceptional ability or special qualifications. So the current regulations does not have these powers that the HOD can increase somebody's salary other than what you have been appointed to do. So this one, it says, can it allow the HOD, if it is within to the extent prescribed? This is what clause number 17 it says. And then clause number 18, it seeks to amend sections 38(2)(bi) of the Principal Act, which deal with the recovery of the remunerations that was wrongly granted to an employee. This is in line with the court order from the constitutions that there was an employee who was wrongly paid, and then the departments or governments decided to recover that money because you were wrongly paid. Now the officials went to court and win the case, and the court order, it says you cannot deduct that money without the consent of an employee. So before you can deduct it, you still need to consider and have a negotiation with the employees to say, we have paid you wrongly, we need to deduct this money, and then you must be agreed. So this clause is to be in line with the court order, that if there is any abnormal payments done to an employee, we should be able to recover that money. But we will consider and we will consult and we will get and consensus with the employee how the money can be recovered. But in case if the employee does not want to comply, we will still end up recovering the money. But at least we need to consider the employee concern. And then clause number 19, it seeks to clarify the interpretations challenges in sections 42A(3)(a) of the Principal Act insofar as they relate to the President's powers to delegate matters related to the appointment and career incidents of the HODs. This section is proposed to be amended to substitute the current reference to Deputy President and the Minister in the Principal Act with reference to a member of Cabinet. Then clause number 20 is the last one, Chairpersons, just to say, can, once this act it has been enacted, can it be shortened to be called a Public Service Amendment Act 2023? Chairperson, I am done. I will give back the powers to you for any question.
Thank you very much, Doc. One must commend you for keeping time. He made his presentation on exactly 25 minutes on the dot. That's commendable. Okay, we are now going to take engagements and oral submissions from our members of the public. We are going to start here in Francis Bard by raising your hands would take your submissions. There's a one, there's a hand. There's two. In that order.
Thank you, Chair, again. My name is again, still remember maybe my name, but let me give it to you. Jan Low, Mahare Municipality. Yes, Chair, I've been reading through clause, I think it's clause 5, clause 7, 11, and clause 12. It really puts the HED in a position, the word may. It really limited the powers of the HOD. If somebody may do something, which means it's not binding, and if it can be taken to litigation in a court of law, you will find that really there will be problems with that word may in the context of powers. You will find that the word may is not binding. If I may deploy or employ people, I had the liberty, I can decide whether I must or whether I may not. So the binding word must be must. If it comes to the legal context, it must not be may. May it's not binding. And he can lazily lay back, it say, no, I may, but I don't want. You don't bind him. Thank you, Chair.
Chair, Mr. Lowe, there's a second hand.
Oh, thank you, Chairperson. Chairperson, my question was on clause 16 of limitation of political rights of section 36A. Chairperson, the question I want to cast to this forum today here is the limitation of political rights. Would it be in friction with the landmark constitutional court ruling of SAMU versus corporate service department, Chairperson? We understand the landmark ruling, Chairperson, when it comes to the accounting officer, which is the municipal manager, where it can't be holding political office, political position while it's in office. But the subordinates of the accounting officer, the ruling is clear that they can hold political office. But in the limitation of political rights under section 36A, it goes further and says those who are also subordinates can't hold, who report directly to the accounting officer, which is the HOD or the municipal manager, can't hold political office. So can't we check between if there's no friction in the two within the landmark constitutional court ruling and the limitation of political rights as it appears on section 36A?
Thank you. Can you kindly state your name?
My name is Tawasi Kawako from Pokwanis. Thank you.
Thank you very much. Can we then check with the other regions, ZFM? Yes, you are recognized from ZFM.
Yeah, Chair. The previous speaker, Chair, was not audible enough for me.
I couldn't get you.
I say, Chair, that the previous speaker wasn't audible enough for me, Chair. I couldn't make out what the previous speaker was actually implying to or addressing. So the previous speaker wasn't audible enough.
Yeah, are you from ZFM? I want to check who's speaking so that we... Is it Honorable Jaffa?
Excuse me, Chair. Excuse me, Chair.
Yes, can you, when you speak, because you are in a virtual platform, can you kindly indicate your name and where you're from?
It's Honorable Jaffer here, Chair.
Oh, Honorable Jaffer.
Yeah, the previous speaker wasn't audible enough for me, Chair. I couldn't make out what he was saying. It was a loud echo.
Oh, the last speaker. Okay.
Yes, Honorable Chair.
So
Yes, Chair.
should we give him a chance to reiterate, or should I just summarize what he was saying?
I think, Chair, would, for continuation, I would rather have the minutes then be forwarded to us as honorable members, so that I can actually go through what the previous speaker was actually saying.
Thank you very much,
Instead of wasting time, Chair.
Thank you. There's another hand. Is Yoliswa Makasi from?
Thank you, Chairperson. My name is Yoliswa, and I come from the New South Institute, and we just want to highlight that we do support the amendments that are proposed by the department, which have been submitted, which have gone through the processes that are required. We do support the devolution of administrative powers from the executive authority to the heads of departments because this is premised on the National Development Plan, and there is a requirement to realign administrative powers such that financial and administrative powers are devolved and centralized with heads of departments, whilst the more strategic powers are with the political principals, which is the executive authority, just to ensure stability and efficiency in the public service. On the limitation of political rights, which I think is clause 16, we also support this clause because we know that it's important to separate politics from running administration and government. And we are happy that the limitation is only for the heads of departments and those who report to them, and it's not encroaching on the rights of the workers in totality in the public service, and it is justifiable. We've also read the Constitutional Court, the recent Constitutional Court decision on local government and limitation of political rights for employees, and that decision of the Constitutional Court is directly aligned with the proposals that are coming up from this particular legislative amendments, and we support that. Whilst we support, as a last point, Chair, whilst we support this devolution of roles and responsibilities to the heads of departments, we also just want to highlight that the heads of departments, in terms of our understanding of the legislation, continue to report to the MECs and the ministers in national departments and provincial departments, and that they are required, there are checks and balances that have been put in place in terms of the amendments, where the accountability of the head of department to the executive authority for administration of the department and functional areas of responsibility, and also to support the executive authority in their strategic roles and constitutional roles that they need to deliver on. So we are happy with that balance, that was to delegate, was to devolve the powers, because they are needed to be devolved to separate roles and responsibilities. There are checks and balances that are being put in place to support that devolution. And we will make a formal submission, Chairperson, in writing, and we appreciate this opportunity to participate. Thank you.
Thank you very much, Ms. Yoliswa. Do we have the hand of Gregory?
Okay, thank you, Chair. That one more, that it's Greg Nyongani from Nahau. That, Chair, we did listen to your presentation now, but we will then do a formal submission to the team. But there's a number of things that we need to raise in the presentation. We need to be very clear from a legal context that when it's starting may or might, we need to be very clear when you write legislation that it should not be may or might, it should be on a legal framework and say that this is a position that on the paper is saying that on the powers then of the HODs. Because the moment we start looking to may and may have a problem then and basically say that how to contextualize then the Labor Relations Act in terms of your amendments to streamline the same processes when it comes to, because when we start using those words may or might, it creates a confusion in the roles and responsibilities, say that what are our functions and responsibilities in terms of law to these HODs. That's one. Two, that we also need to raise then the issue that in the same amendments that can you also do a review then on the HO8 principles then in terms of the regulations to be then become a customized part of the process then of the legislation, because the allegations are very clear. It will also be able to enforce then certain rights in the performance agreements and performance management systems so that they can be held accountable and obey that. And then the one thing we also need to have then in the legislation, which is not there, the issue of experience and qualification must also be enforced in the amendments. So the head of departments must be on the same level of accountability and the issue of qualifications. It should not be an influence of certain issues as well when it comes to it. Those issues will be able then to start looking into Chapter 2 of Bill of Rights, that there may not be limitation of rights. What is fair should not become unfair, discriminatory, but it should be balanced then. And then the one level that the Act is also not very clear on your amendment is the issue of retirement age. Because we need to be able then to level our retirement age legislation in this country. It cannot be a right that a judge can retire at 75 years, while then a police officer can retire at the age of 60 years. And administration in a police person can retire at the age of 65. Let's balance the legislation that when we talk retirement, it should include all of us in a manner of a number of regulations in the country to have a balanced act so that the constitutionality of the act needs to be done. The last thing I want to raise this team today, that Section 118 of the Constitution is very clear in the issue of public participation. The committee must start implementing that so that those who are going to make submissions today, that the 118 should become clear in bracket C that this amendment should be done and as part of public publication in the province. Thank you, Chair.
Thank you very much, Mr. Gregory. These are the hands we've received from our hybrid platform. We are now going to go ahead to hand it back over to the department through Dr. Foromo to respond to all the questions that have been posed to him. Thank you very much.
And I think it's more on submissions to the committee. The second, I think the issue for may and must, I think it is submissions that the committee, they will actually look on it when they make their submission from the province. Others were comment about the Act, its silence on the experience and qualifications of the HODs. I think those ones, they are addressed in the professionalizations of the public service. So it is not everything that we put it into the Act, but there is other enablers that have got a similar power like the Act, whereby we can release a circular and stipulating the requirement of the recruitment processes that it's needed in all cadres of government. So that one is covered somewhere else. And then including the issues of the age of the judge and the SAPS and others. This is the public service amendment bill. So it deals with the people who are appointed by the Public Service Act. And then there are those one who get appointed by the SAPS, whereby there are limitations of age retirement at 60. There is a need for them to do that. They need somebody who will be active, probably, into the police service, that if one is 70 years, you may not be able to run after the criminals. So probably they were looking on those ones. And in terms of the judges, also, it's falling on other scales. But all these submissions, it will actually, it is submitted to the committee, which they will summarize it and they will put it into their formal submissions to the NCOPs. Chairperson, I hand it over back to you. So unfortunately, the second member, I only heard him when he talked about clause 16, but the rest that he was saying, I didn't hear him at all. But I guess the submissions, the committee have heard it, and then they will address it. Thank you.
Thank you very much, Dr. Foromo, and to Mr. Governor for your presentations. We would like to all our members of the public that have joined us, that we are going to allow for written inputs to be submitted to the relevant committees, and the officials will give you the relevant details. Your inputs will have to reach us before the 2nd of May 2025. And after inputs have been received from stakeholders and the public, the committee will then convene and give due consideration to these inputs and develop and agree and vote on negotiating mandate. The NCOP Select Committee considers the inputs and will transmit the minutes of the discussions with explanatory notes from the departments on the province's concerns. After negotiating mandates, the legislature submit a final voting mandate. The delegation from the province must then vote according to the mandate given to them. So, honorable members and to the public, we want to thank you for your participation and your time that you've afforded us. It was not an easy meeting to convene due to our technical glitches we encountered. But before we can formally close, there's something that we didn't do. We did not introduce ourselves formally on record. So I will just start with the Honorable Jubed to place it on record, introduce himself, and then to the officials that have accompanied us.
Thank you, Honorable Co-Chair. Yes, I'm Honorable Jubert. I'm also the chairperson of the Committee on Kochsta in the legislature. Thank you.
Thank you, Honorable Member. Good afternoon, everyone. It's Lungile. The surname is Mbata. I'm the acting coordinator for Kochsta.
Thank you. Thank you very much, colleagues. My name is Tabo Janchis. I'm responsible for the Standing Committee of Constitutional Affairs, Petitions, Public Participation, and it also appears there if you might miss me. And if you meet me everywhere you want to give me before the time that is allocated, feel free to do that. Thank you.
And my name is Honorable Donovan De Hayes. I'm the Deputy Chair of Chairs in the Northern Cape Provincial Legislature, and I'm the one that was chairing the Standing Committee on Constitutional Affairs just now. So members of the public and across all regions, I've been told that there's something to grab when you leave. I would suspect it's happening everywhere across the province, just to grab and nibble on. I wouldn't tell what is it, but it's just an announcement that I'm making with you. So for your time, we want to highly appreciate your presence. We want to highly appreciate your contribution to this hearing. We thank you, and this hearing Okay. So I was just informed that they are going to confirm if food is already here. So thank you very much, members. The meeting is therefore adjourned. Ra leboga.